and he braced himself because he knew that our co-defendant would be colliding into him. So based on everything that's been conducted so far in the 2 years since this case has been going on, there's no evidence whatsoever to support any of the elements that my client was negligent in this case. Plaintiffs can't satisfy the necessary elements for a negligence claim. There's nothing linking the alleged damages that plaintiffs sustained to any actions committed by my client. And as such, on behalf of Samuel Silva, we're requesting this court to grant his motion for summary judgment and dismiss the plaintiff's claims against him with prejudice.
All right, thank you, sir. Mr. Santos?
Yes, Judge. And this is actually a unique, I would say, situation. In most typical cases where you've got multiple impacts, there is inconsistent as far as the allegation of one primary impact, which pushes the car into the other vehicle, which, causes this, chain-like reaction. There is a dispute as to that in this particular case. And so that's what makes it important. And just by way of history, when we initially, in prior to the lawsuit, we had filed this claim or made a claim and made the claim against, defendant Garcia. And at that point, that's when it was indicated to us that there had been, really two impacts, and that the carrier for Hugo Garcia was denying any type of coverage or any kind of liability at that point because there had been the alleged, there had been, two impacts in the vehicle or to her vehicle, my client's vehicle. But kind of taking, that's how we got here, and that's how the two defendants were brought in. But kind of taking this back to what's on file and before us, today, what we have is a no evidence motion for summary judgment, and it's kind of in reading their motion, it's kind of clouded in, either a no evidence or a traditional sense, and because they've attached some evidence and some information to, and really helps kind of support some of these elements. And so for us to properly defeat this MSJ before us, we've got to prove up, that there's sufficient evidence on, on the three elements of negligence. And the court's well aware of, these elements, and having tried, thousands of cases, we're looking at, the elements of duty, the breach of that duty, and then the damages. And really the duty is pretty straightforward, right? We all know that he has a duty. Mr. Garcia has a duty, and actually everybody that's, driving in a vehicle has a duty to other vehicles, other, passengers, other people, on the street. So it's clear that Mr. Silva was in a vehicle behind, my client, Ms. Segovia, on the same street, directly behind. And so at that point, yes, he did maintain or did have a duty, to my client. And so I think that's pretty straightforward, and that's based off, the police reports, based off obviously multiple testimony, and it's really undisputed at the end of the day. I think the crux of it and what it comes down to is, okay, was there a breach of this duty? And what did, Mr. Silva do to contribute, to this breach that was owed to Ms. Segovia? And there's two arguments that can be made, or 2 points based on the testimony. There is some inconsistency with the testimony. I know Mr. Garcia testified or couldn't recall that there was either no screeching brakes, or doesn't recall if he, what exactly happened as far as the brakes occurred. But it was very clear that my client, did, feel the screeching or did hear the screeching, which alerted her. At that point, she did look up, and she did see Mr. Silva's vehicle coming into hers and impact her vehicle from behind. So whether that is, as a result of him being pushed into, to Ms. Segovia as a result of Mr. Garcia, or he did that on his own, that's a disputed fact. But either way, at a minimum, you got to take it as evidence, and that's what we're here for, before you today, as far as a no evidence summary judgment. So we've got that dispute. It's undisputed that, and the evidence shows, in terms of even pictures, police report, whatever it is, and even testimony, that he had damage to the front of his vehicle. My client had damage to the rear of her vehicle. So we know there was an impact. The other thing is, in the alternative, whether there was two impacts or one impact, another portion that we have in there is that he has a duty part of his duty is to maintain a safe distance. And so even if he were to argue that, hey, there was only one impact and he was pushed in, we would still maintain that he should have maintained a safe distance, which would have prevented him from hitting our vehicle. But so those are the primary, points that I would bring up at this point.
Okay.
And then take it from there.
All right, Ms. Saldivar, did you want to say something?
Yes, Your Honor, if I may add, I understand I don't really have a dog in this fight. It's not my motion or my response, but for what it's worth, our position is, of course, against the granting of the motion. If you listen to Mr. Young's arguments, first, we are here for a no evidence summary judgment, and the standard of proof on that is the absence of proof. Mr. Young brings up the police report, Mr. Garcia's depo, both of which is evidence. And it's up to the jury to determine the weight and credibility of that evidence. As far as the police report only naming one contributing factor, well, that police report isn't into evidence yet. And it's not guaranteed that that police report will get into evidence. And so it's up to the jury to weigh all of these facts. And it sounds like throughout the summary judgment and in Mr. Santos' response, we're talking about proportionate responsibility here between both defendants and possibly plaintiff if any evidence arises. And that, of course, is the most sacred part of jury apportioning responsibility between two defendants. Just because the police officer may have determined it's only one defendant doesn't mean that the jury will give it that credibility. And so we do think the motion should be denied and all these facts should be presented to the jury. And if the jury comes back with zero proportionate responsibility to co-defendant, well, that's their job, not this court's job. It is not a matter of law at this point, and there is far more than a scintilla of evidence to show that some responsibility may be apportioned to Mr. Silva.
Your Honor,
yes, sir.
Okay, as counsel has put forward, which is true, this is a no evidence motion for summary judgment. And even with that, we have to state the elements for which there is no evidence. Mr. Santos clearly covered, the duty that my client had, and he didn't breach his duty because he remained stationary behind the plaintiff. But for the other elements of negligence to which there is no evidence, there is no evidence linking my client's involvement of this accident in the causation of this accident.
If I may respond, Your Honor, there is evidence, and I believe Mr. Santos attached it as Exhibit A to his motion in the deposition of plaintiff. Plaintiff was asked point blank if Mr. Garcia, my client, ever touched her vehicle, and the answer was no. And so I understand Mr. Young's point that Mr. Young is saying that the rearmost car, Mr. Garcia's car, was the sole proximate cause of the accident. But again, that's a question for the jury. That's a question, of course, we in our defense will present that if Mr. Yes, Your Honor.
Okay. What the court will do here is go ahead and take the matter under advisement, and hopefully I'll rule in about a week or less and submit your proposed orders. Okay, Mr. Santos and Mr. Young.
Yes, sir.
Yes,
All right.
Judge, quickly,
Well,
I was wondering if we were going to have a Biden-Trump discussion, or if we were going to have a Harris-Pence debate. I didn't know which way it was going to go, but I was glad.
The fly is not here, so I think we should put that off for another day.
The most
Just
famous
so all
fly.
parties can be present.
We didn't start yelling at each other and calling each other names. So
No.
I'm already too scared of you guys. I'm the first-year attorney, so
No, these are
I'm
civil
not going to be
cases.
taking fits.
It's supposed to be civil cases. Okay, thank you all so much. Have a great
Thank
day.
you,
You all may be
Judge.
excused.
Have a good day. Thank you.
Bye-bye.
Bye-bye.
Bye-bye. Who's next?
I'm gonna do Mr. Larson,
Larson,
Lamerson.
Lemerson, and Irvin.
Let me see.
Okay.
Let me see, Irwin.
All right. That's Mr. Lamerson. I see him on the screen.
Morning.
Good morning, sir. Alan Irwin or his designee. Anybody that we know that's going to be coming in for him?
I don't know, Judge. If they're not here, we're okay with dropping the setting. It's their motion for summary judgment.
Okay. It's I'm trying to look for somebody here in the living room. Waiting room, sorry. I don't see.
That's what happens when they don't put their case.
Yes. It would be nice if they put their case number next to the name, just like Mr. Lamerson did,
Thank you, Judge.
so that we'll know, hey, you're here for this case. Let's match you up and let's have a hearing. But
Let's do this one first.
Okay.
173099.
okay, 17, which is that one? Okay, we have here, I have CL 173099D, Geico versus Andrew Rodriguez.
Yes, Judge. This is Geico's motion for summary judgment.
Okay, sir. Anybody on the other side? I mean, no attorney?
No, he's not military. Yeah, he's pro se. He has, according to him, retained a bankruptcy attorney, but there's been no appearance in this case by any attorney, nor anything from the bankruptcy attorney.
And no response to your motion either?
No response, Judge.
All right, court will take judicial notice of the entire filing, cause number CL 173099D in the case of Geico versus Andrew Ray Rodriguez. Okay, Mr. Lemerson, you may proceed, sir.
Yes, Your Honor. This is our motion for summary judgment. Our motion for summary judgment is based upon two grounds. First, that the defendant has wholly failed to respond to a request for admission. The request for admission that he did fail to respond to are attached to the motion. They demonstrate that he is liable for this accident and that the damages that were incurred are true and correct. We've also attached our notice of filing business records affidavit, including in those notice of filing business records affidavit, the police report demonstrating that he was liable for this accident, and also a list of our various damages, which in this case total $31,977.55. We are seeking that $31,977.55 plus statutory interest and reasonable attorney's fees, totaling amount of $750 pursuant to the Texas Transportation Code. I've attached an affidavit to the motion for summary judgment detailing that these are necessary and proper attorney's fees. At this time, we'd ask that the court grant judgment in this case.
All right.
He filed back on May 21st of 2020.
Okay, court will hereby grant the motion for summary judgment, and we'll go ahead and grant movement all relief requested here in open court, and court will await an order for signature or judgment. Did you submit something already, Mr. Lemerson, on this one?
We did, Judge. It was May 21st of 2020. We submitted our proposed order.
Okay, it's been submitted, so then I'll go ahead and look for it so we can sign it.
Perfect. Thank you.
Now, going back to CL 185938D, Geico versus Cynthia Elizondo. I have here attorney Ellen Irwin, but I don't see him.
Good morning, Judge J.D. Vela here, appearing for defendant Cynthia Elizondo. I'm appearing on Mr. Irwin's behalf.
All right. Good morning, Mr. Vela.
Yes, Judge. Good morning.
All right. And Mr. Lamerson. And it's whose motion for summary judgment?
It's our motion, Judge.
All right. Go ahead.
All right, Judge. Before I get into the motion, Your Honor, I wanted to give this court a brief overview of the facts. This is a case where plaintiff Geico is seeking to recover some monies that were paid for their insured Bobby Rodriguez as a result of a car accident. Now, the car accident involved two vehicles. One was driven by my client, Cynthia Elizondo. The other vehicle was operated by Edgar Sandoval, who was intoxicated at the time of the accident. Plaintiff's insured was a passenger of Mr. Sandoval's at the time of the accident. So, Your Honor, our position on this is simple. This accident took place because Mr. Sandoval was drunk, he ran a red light, and he was speeding. It's plain and simple. Plaintiff has produced no evidence whatsoever suggesting any fault on my client. In fact, their response to our motion for summary judgment cites the police report as being sufficient to overcome the MSJ. Now, the police report states that my client had a green light and was proceeding through an intersection, and it also states that Mr. Sandoval ran a red light and collided with my client's vehicle. The police report also cites Mr. Sandoval for the accident and cites him for driving while intoxicated. In fact, it lists Edgar Sandoval as a sole contributing factor for disregarding a stop and go signal and for driving under the influence of alcohol. My client wasn't cited in relation to this accident, nor was she listed as a contributing factor. So, Your Honor, the police report doesn't create a fact issue. It supports why the motion for summary judgment should be granted. On top of the police report, Your Honor, we took 3 depositions in this case. We took the deposition of the investigating officer, Bobby Rodriguez, who's plaintiff's insured, and the drunk driver, Mr. Sandoval. Now, the police officer reiterated what was in his report and stated that Mr. Sandoval was at fault for the accident for disregarding a red light. He also discussed his basis for citing Mr. Sandoval for driving while intoxicated. He stated that he conducted a field sobriety test, an interview, and he even got a breathalyzer sample from Mr. Sandoval, which stated that Mr. Sandoval was over twice the legal limit. Plaintiff's insured didn't believe my client did anything wrong. Rather, he provided more context to the accident. He said that Mr. Sandoval took a wide turn immediately before the accident and sideswiped another vehicle that was stopped at an intersection waiting for the light to turn red, or waiting for it to turn green, rather. After sideswiping that vehicle, Mr. Rodriguez said that the driver panicked, started speeding, ran a red light, and that's what led to this collision. Mr. Rodriguez also said that he didn't believe that the driver was capable of driving. He said he didn't seem up to driving. And he specifically stated that he thought that the driver was speeding. And then we also deposed the driver. The driver couldn't remember much. He admitted that he had been drinking earlier the night. He admitted that he was buzzed when he left a party, and he could not disagree. He didn't disagree that he ran a red light, and he did not disagree that he was driving while intoxicated. And more importantly, he couldn't list anything my client did wrong either. In short, Judge, plaintiff has no evidence to support their claim, and that's why I'm asking that you dismiss this case.
All right, Mr. Lemerson?
Yes, Your Honor.
Yes, sir.
The evidence that the defendant is producing here, no evidence for summary judgment, it goes to the weight of evidence, not to the sufficiency. We filed a response to their motion for summary judgment, attaching to it the affidavit along with the police report and all the medical evidence demonstrating that what we're seeking is true and correct. We believe that there is a scintilla of evidence for us to proceed in this matter. The motion for summary judgment is not proper. Further, this case hasn't mediated. We filed a motion to compel mediation, which is not before the court today. However, should the court wish to take this up, we'd ask that the court hold a ruling in abeyance pending a mediation between the two parties. Thank you.
All right. Court will go ahead and take this matter under advisement. Submit your proposed orders.
Your Honor, if I may add one more thing.
Sure.
I would like to point out the fact that during all three of the depositions of the police officer, the insured, and of the driver, plaintiff's counsel did not ask any questions regarding what color the light was, regarding anything. They didn't ask any questions.
That's correct, Judge.
I would like the record to reflect that.
If I could just respond, Judge, I reserve my questions until the time of trial. That's just my strategy. It's what I always do.
All right. All right. Once again, court will take this matter under advisement, and we'll go ahead and review the motion and response, and any affidavits attached there too. Submit your proposed orders, and let me see where we're going to go from here. Okay. Thank you, gentlemen. You may be excused.
Thank you, Judge. That's all I have. May I be excused?
Yes, sir.
Thank you.
Thank you. What you want to do now? Yes, sir, Mr. McGuire. You're here on which case?
Good morning, Your Honor.
Good morning.
It's Ford Motor Credit versus Marta Melendez and David Melendez.
Oh, okay. Number 8. All right, that'll be I think it's CL 194493D, and that'll be Ford Motor Credit Company LLC versus Marta Melendez and David Melendez. I don't see them in the waiting room. And
Judge, for the record, this is the bailiff. Mr. Melendez, David Melendez, is currently at the courthouse. He should be logging in. I gave him instructions to log on with the meeting ID and password, sir.
Okay. All right.
Ms. Marta Melendez will not be appearing per Mr. Melendez's statement to the county clerk downstairs.
Okay.
I do not show an answer on file for this case, sir, on a response.
All right.
Your Honor, may I be helpful here?
Yes, sir.
I would like the opportunity perhaps to speak with Mr. Melendez. Maybe we can work something out.
Okay. Yeah, let's wait and see if we need logs in so we can go over that. Okay, thank you, Mr. McGuire.
I'll stand by. Thank you.
Okay, thank you. No, number 12, let me see. I have Mr. Jonathan Almanza. See, oh yeah, there you are. Can you hear me, sir? Let me see. Are you, I think you're muted. I don't hear you.
Is this better? Can you hear me now, Your Honor?
Now I can hear you. Yes, sir.
Thank you.
I think you're here on CL 20-3339D.
Yes, Your Honor. Jonathan Almanza, regarding CL-20-3339-D. This is an appeal from an eviction in JP Court.
Uh-huh.
Your Honor, I had filed a motion for continuance. I was retained on this case the same day that the last day that my client could file a notice of appeal. They've been working in rural Oklahoma, so they haven't been in the Valley since this.
Okay.
I've not been able to meet with my clients in person. They don't have internet access. Miss Melissa Guerra is the wife of Adrian Guerra. She is attempting to use the limited cell service they have to attend via telephone. I had requested a reset. There's an eviction moratorium on right now, Your Honor. My client put a $3,000 bond, and they've been making payments on the rent. We were just hoping for 30 days to get all the evidence together, and we do think that we resolve.
Okay, you were breaking up, Mr. Almanza. I was hearing bits and pieces. I don't know why there was some interruptions or you were breaking up.
Can you hear me now, Your Honor?
Okay, I can hear you now, but on the last part, I didn't hear nothing. You represent who now?
I represent Mr. Adrian Guerra, the occupant, the tenant.
Okay, and who is Melissa Guerra?
That's his wife, Your Honor.
Oh, okay. So, because I think she's on the screen here, or just a name.
Yes, they're in rural Oklahoma, and it's really bad cell service. She says every time she tries to do the audio, it just throws her out. She's able to hear, but they have almost no cell service.
Oh, okay. Now, you represent the Guerras, right?
Yes, sir.
There was a JP judgment?
Yes, Your Honor, but the address on the notices and the service were wrong. My clients didn't get notice until after the order was signed. The landlord went in and said, I'm going to evict you. Well, that's when my clients got notice 2 hours before the expiration of their notice of appeal, which was Friday, August 12th. They called my office, very emotional. They had tried to call 3 attorneys from Oklahoma, from Oklahoma down here. Nobody wanted to take the case. I agreed to drive to JP Court, file the notice of appeal, put the bond down. They hadn't even, paid a retainer yet, but it was that or they were going to get evicted. My clients put the $3,000 cash bond, and then the President Trump signed the eviction moratorium. So now we obviously don't have until December. Not been able to meet with them in person or even via video because of he's working in the fields out there in Oklahoma.
Oh, okay. I have somebody else here, Galaxy A11. I don't know who
That's me, Judge David Melendez. I don't know if because I can't see it because my phone. I don't know what's wrong with it.
David Melendez is with McGuire. Okay, just hold on.
Okay, Mr. Melendez. Mr. McGuire is the attorney on the other side. I guess you need a chance to speak. Mr. McGuire, do you want his phone number right now, or how do we do it?
Yes, sir, if that be possible.
Okay, Mr. Melendez, give us your phone number.
That's area code 956. Phone number 739-4602.
956-739-4602.
That's correct.
Okay, very good. Mr. Melendez, I'd like to give you a phone call. Maybe we can work this out. Is that okay?
That's fine. Go
Okay,
ahead.
very good. I'll call you right now if you look forward to my call. Thank you, Your Honor. I'll stand on.
All right, thank you, Mr. McGuire.
Thank you, sir.
Thank you, sir. Thank you. All right, I want to know who. Let's see. Oh no, that's Galaxy. Okay. So, Mr. Almanza, you represent the Guerras, and there was a judgment against them in JP Court. They filed a bond to appeal, right?
Yes, Your Honor. And I just want to say the address that was on the original petition, the notice of hearing, was not their address.
Okay.
And the landlord should have known their address because he's renting to them. but it was an incorrect address, so they did not get notice of the hearing. They were in Oklahoma at the time as well.
And the name of the landlord?
Chauncey Vontine or Vontine, I'm not exactly sure how it's pronounced.
Vontine or Vontine. I just want to make sure they're here or not.
No.
I don't see them on the
Waiting.
waiting room. Okay, we'll do a reset.
Thank you, Your Honor.
Yeah, submit me an order setting hearing date. Okay, sir?
I will, Your Honor. I'll do that today.
Yeah, please, with everybody's address.
I will, Your Honor.
Okay?
Thank you, Your Honor. You have a nice day. Might be excused?
You may be excused. Thank you.
Yes, sir.
Reset. Okay. Who's next? All right, let me see here. I see Mr. Perez and Miss Jennifer Olivares. Can you both hear me?
Yes, sir.
Yes, sir.
All right. I have a question. Are we here on
Okay.
are we here on in the interest of Eliza Perez?
Yes, sir.
Ms. Olivares, you need to go into a room. There's a lot of noise in the back.
Okay.
Yeah. All right. All right. Can you hear me now, Miss Olivares?
Yes, sir.
All right. Thank you very much. Now it's quieter. It was too noisy a while ago.
Yeah, I'm sorry about that.
Robert Jackson, the attorney, who does he represent?
He represents me.
Who? Oh, he represents you?
Yes.
Is he going to be showing up?
I don't know, sir.
Judge, for the record, I made contact with Attorney Robert Jackson's office. They are telling me that Mr. Jackson is having some issues trying to log in because of the area that he lives in.
Oh.
So he's trying his best to try to log in.
Okay.
And that
Did
is
you
all
hear
the-
that? Did you all hear that?
We'll give him a few minutes.
Yeah, but let's give Mr. Jackson a few more minutes. So we'll put you on hold for a little while.
Hello, Judge. Judge, yes, sir.
Yeah. Oh, yes, sir, Rick.
Judge, I just got off the line with Attorney Robert Jackson's office that they are unable to get through to Mr. Jackson at this time. They just wanted to let you know.
Okay, do they want to reset then?
They're probably going to request a reset date. Yes, sir.
Okay, it'll be a reset then. Let me, okay, Mr. Perez and Ms. Olivares. We just got another phone call from the Jackson office, and they're telling us he will not be able to log in. So we're gonna have to give it a reset date. Thank you all for showing up and waiting and so forth. But we'll give it a quick reset. We'll just leave it up to him to see when he's ready. Can you all hear me?
Okay, sir.
Hear me, Mr. Perez?
All right. Yes, sir.
It'll be through Zoom.
Yeah, it'll be through Zoom again. So once we give you another notice, it'll be some more, a new password, new information. So, but I thank you guys for showing up, and it's just that Mr. Jackson couldn't do it. And Mr. Olivares, when you do log in next time, next to your name, type the case number. And so,
Okay, ma'am.
just like Mr. Perez did, and it's easier for us to find you in the waiting room, and we'll bring you in right away. Okay?
Judge, and for
Yes,
the
sir.
record, can Mr. Perez provide the court with an email address? Because I know that he called me yesterday that I had to give him those instructions over the phone. If he can provide an email address to the court.
All right.
Yes,
Can
sir.
you do that? Can you do that, Mr. Perez?
Yes, sir.
Do you want it right now?
Go ahead, sir.
Give it to me.
It's LILK 2 I's NG 233 @gmail.com.
Mr. Perez,
Okay.
may I have your number, please? Telephone number.
956-599-2707.
2707.
Yes.
Yes,
Okay,
sir.
sir. Well, if I have any issues, I'll call you back. Okay, sir.
All right, sir.
Thank you.
All right. Thank you very much, Ms. Olivares and Mr. Perez. You may be excused. Thank you. We're gonna go back, Mr. McGuire. Okay.
Your Honor?
Yes, sir, Mr. McGuire.
Yes, sir. I had a considerable phone call with Mr. Melendez. He's coming back on Zoom. I think we should wait until he comes back on. I promised him that he should do that.
Okay.
I'll just say this. Well, maybe I should wait and tell you when he comes back on, but we'd like to pass on our hearing today.
Oh,
We'd
okay.
like to work something out with him down the road, but in courtesy to him, I think we should wait until he logs back in and we can inform him.
Oh, okay. Very well.
Okay, thank you. I'll stand by.
Yes, sir. Mhm.
Thank you.
Okay, now, Mr. McGuire, I don't see Mr. Melendez in the waiting room. What we're gonna do is just go ahead and not take no action here today.
That's correct.
Allow you folks to work it out, and if it doesn't, just set it for hearing again.
Okay, very good, Your Honor. Thank you so much for your time today. I apologize. We always try and reach out to our folks to see if we can work something out. And he explained his circumstances. I don't wish to go over them now, but we have an understanding. So we'll get with you later if we need you. Thank you so much today.
All right, good deal. Thank you all so much. Thank you, Mr.